Hello and welcome to today's session in relation to data protection complaints. And this is to cover the new requirements and practical steps that law firms need to be aware of in order to meet the obligations of the Data Use and Access Act. Okay, so we're talking about this now because Data Protection Act or Data Use and Access Act has recently been introduced, and there's a specific requirement for organisations to have a process in place to deal with data complaints. Now, data protection isn't new, and complaints aren't new, and handling complaints aren't new in the legal sector. However, with the introduction of this piece of legislation, it does set out that there needs to be a clear process, and therefore, in the legal sector, what we need to do is be clear to clients about what that means in relation to escalation in particular. Internally, we need to think about how people are going to recognise what complaint potentially leads to what action, which then leads on to an escalation. So of course, we have everything kind of sits under the umbrella of the SRA Code of Conduct for Solicitors 2019. And ultimately, we've got regulatory obligation to make sure we follow the law, which means that we need to comply with all relevant legislation. So this is one of those pieces of legislation, but we also need to maintain effective systems and controls in place, which means looking at what our complaints handling process looks like in practice and ensuring that we are acting in the best interests of the clients, that we are being transparent with them in relation to how we will handle those complaints. And of course, we have the legal ombudsman who oversee the service complaints within the legal sector. So there's lots of different things to think about, but hopefully this short webinar will just guide you in relation to what you might be thinking about and what changes you need to make to your current internal processes.